Imagine sinking your life savings into a well-known franchise, following their playbook to the letter, only to find yourself entangled in a costly lawsuit, accused of breaching the very agreement you thought you understood. Or worse, you're the franchisor and one rogue franchisee is destroying your brand's reputation, refusing to comply with standards, and daring you to enforce the contract. Franchise disputes in Florida are more common than most people think and more destructive than they realize. But the good news, they're also winnable if you know where the landmines are. I'm Santiago Cueto, board-certified international business attorney and best-selling author, advisor to some of Florida's most successful franchisors and franchisees. Today, I'm going to walk you through the top 5 most common franchise disputes in Florida and how to win them. Dispute number 1, the breach of franchise agreement. At the heart of every franchise relationship, there is a franchise agreement. It's thick, it's dense, and often heavily favors the franchisor. A common conflict is where a franchisee is accused of not following brand guidelines, underreporting income, or operating outside the protected territory. But here's the power move to win. Whether you're the franchisee or the franchisor, success in these cases comes down to documentation and compliance. Franchisees must show strict adherence to training manuals and email correspondence. Franchisors, on the other hand, should always maintain audit trails, territory maps, and detailed records of policy violations. And remember, in Florida, ambiguous contract terms are construed against the drafter. That could shift leverage to the franchisee if the agreement is poorly written. The most common dispute number 2, non-compete enforcement. A franchisee ends the relationship, but opens a similar business nearby. Now what? A common conflict in this area arises when a franchisor tries to enforce non-compete clauses. Franchisees argue they're overly broad or unenforceable. Here's the power move to win. In Florida, non-competes must be reasonable in time, geography, and business scope. Courts won't enforce a clause that's vague or overly punitive. Franchisors win when they show the clause protects legitimate business interests, like proprietary processes or customer goodwill. Franchisees win by showing the restriction is so broad it prevents them from earning a living. The most common dispute number 3, misrepresentation and fraud. Before signing, the franchisor makes glowing claims about earnings, foot traffic, or support. After signing, none of that pans out. This is a common conflict that occurs when a franchisee sues for fraudulent inducement. Franchisors claim the franchise disclosure document, or the FDD, spelled everything out. But here's the power move to win. Franchisees can win if they prove they relied on verbal promises or marketing materials that directly contradict the FDD or earnings disclaimer. Franchisors should keep all communications aligned with the FDD and have franchisees sign acknowledgement forms. The more paper armor you have, the stronger your defense. Here's dispute number 4, royalties and fee disputes. A franchisee falls behind on royalties or challenges the calculation. The franchisor threatens termination. A common conflict happens when franchisees argue the fees are arbitrary or based on faulty numbers. Franchisors push for payment and possible termination. Here's the power move to win. Accuracy is everything. Franchisees should audit the numbers and demand transparency on how fees were calculated. Franchisors should ensure the point-of-sale systems are tracking revenue correctly and that they've got clearly defined gross sales in the contract. In Florida, wrongful termination by a franchisor can result in serious damages, especially if the business was profitable. Don't let sloppy accounting decide your case. Here's dispute number 5, encroachment by the franchisor. Nothing stings like spending years building territory only to have your franchisor open a new location right next door to you. The common conflict here is when franchisees sue for encroachment and breach of exclusive territory rights. Here's the power move to win. Franchisees must prove their agreement included exclusive territory protections, not just vague promises. Courts in Florida will enforce exclusivity clauses only if they're clearly spelled out. Franchisors win when they clearly define what isn't protected and document the franchisee understood those limits. Lack of clarity in the territory clause is the Achilles heel in many of these cases. Franchise relationships can be a powerful path to wealth, but they're also legally complex and emotionally charged when things go south. Whether you're a franchisor looking to protect your brand or a franchisee fighting to protect your investment, the key to winning is knowing your contract, your rights, and your strategy. I'm Santiago Cueto, and if you found this helpful, make sure to like, subscribe, and drop a comment below with your franchise experience or legal question. I'll respond to the best ones in the future videos. Until next time, protect your business, know your leverage, and stay legally sharp.